Mine.
Thank you, my lady. Can I ask you then to turn to Hämäläinen, tab 32 of volume 2, and the Grand Chamber judgment begins at 1165. I wanted to ask you to look firstly at 1171, which in paragraph 28 and 29 tells us how the Finnish law essentially it provided for an automatic conversion of a marriage to a civil partnership and vice versa, provided that the other party to the marriage or civil partnership consented. But if they don't consent, and they didn't consent in this case because of their religious beliefs, then the new gender cannot be legally recognised. Paragraph 31 and 32, then there is a survey by the court of practice in other contracting states, and you'll be familiar with this practice of the Court of Human Rights when it comes to looking at the margin of appreciation and the degree of consensus amongst other states. And para 31, it tells us that 10 member states permit same-sex marriage. 24 states have no clear legal framework for legal gender recognition, presumably contrary to Goodwin. And then 6 member states have relevant legislation on gender recognition, and in those states the legislation specifically requires that a person be single or divorced, or there are general provisions in the civil codes or family law provisions stating that after a change of sex any existing marriage is declared null and void or dissolved. Exceptions to that, which allow a married person to gain legal recognition of his or her acquired gender without having to end a pre-existing marriage, exist in only 3 states, Austria, Germany and Switzerland. So in essence, on the particular issue which arose in Hämäläinen and which arises in the present case, there are only 3 contracting states which would reach a different conclusion to that which is reached under Finnish law and under UK law. So far as the reasoning of the court then is concerned, paragraph 6, it starts at paragraph 69 on 1183, and the court recognises in paragraph 70 that although the applicant is not advocating same-sex marriage in general, merely wants to preserve her own marriage, her claim, if accepted, would in practice lead to a situation in which 2 persons of the same sex could be married to each other. No such right currently exists in Finland, and that is itself compatible with the convention. There's a reference at the top of the next page to Parry in 2006, which of course is some time previously now. Grand Chamber judgment of July 2014, so it's eight years or so previously. You then have in paragraph 73 the reference back to the survey of contracting state practice, And 74, thus it cannot be said there exists any European consensus on allowing same-sex marriages, nor is there any consensus in those states which do not allow same-sex marriages as to how to deal with gender recognition in the case of a pre-existing marriage. The majority of the member states don't have any kind of legislation. The exceptions afforded to married transsexuals in the 6 states, apart from Finland, are even fewer. There are no signs that the situation in the Council of Europe has changed significantly since the court delivered its last rulings on these issues in Paris. So wide margin of appreciation. And 75, this margin must in principle, in the second sentence, extend both to the state's decision whether or not to enact legislation concerning legal recognition of the new gender of post-operative transsexuals, and having intervened to the rules it lays down in order to achieve a balance between the competing public and private interests. So it's a wide margin which applies to the conditions of on which legal recognition will be afforded. 76 onwards, the court goes into the different options which the applicant has, including 77, conversion of the marriage into a registered partnership. Paragraph 81, the Finnish legislature had opted for reserving marriage to heterosexual couples, this rule being capable of no exceptions. As indeed in the UK, does that strike a fair balance? The court has to decide. And paragraph 83 in particular is the finding as to the similarities between marriage and civil partnership. No essential change in the applicant's legal situation were her marriage to be converted into a civil partnership. And the same in this. In the UK, and it's not said that the UK regime of civil partnerships is any different or any worse than the Finnish regime, and it equally presents a more than acceptable alternative. And then the conclusion is in paragraph 87. In the court's view, this is the third sentence, in the court's view, it is not disproportionate to require, as a precondition to legal recognition of an acquired gender, that the applicant's marriage be converted into a registered partnership, as that is a genuine option which provides legal protection for same-sex couples that is almost identical to that of marriage. Minor differences between these two legal concepts are not capable of rendering the current Finnish system deficient from the point of view of the state's positive obligation. And we say that is a clear finding which applies to legal recognition of an acquired gender in general terms across the board. No suggestion that the state has to, or even can, distinguish between certain situations and other situations. This is an acceptable precondition to legal recognition against the world, as it were. And then there's the court's finding under Article 14. Lord Panic has taken you to and very respectfully criticised. Paragraph 111 and 112. We say that the finding that the applicant's situation and the situation of cisexuals as not being sufficiently similar as to be compared with each other, we say that is an entirely understandable and correct finding, that there is no direct discrimination inherent in the application to transsexuals of legal conditions for the recognition of their acquired gender. I'll come on to this in the context of discrimination in a moment, but very shortly, the point is that the only people to whom these conditions apply are transsexuals. They are there solely to determine whether transsexuals can have legal recognition of their acquired gender. There is nobody else who is subject to them. There is no other population with whom they should or could be properly compared. That's the explanation for the court's finding here, and we say the same analysis applies under EU law when one comes back to the directive, as I'm going to in a moment. So we say that the Hämäläinen case is a clear finding that a marriage condition in substance identical to the marriage condition at issue in this case is entirely compatible with convention rights. And I'm going to want to submit that finding reads across and is highly relevant, if not determinative, of the same issue as it arises under the directive. Now, Lord Panic put his case in two ways, in oral argument as he did in his written case. The first way in which he put it was to say that the marriage condition is impermissible because it doesn't relate to whether a person is medically and psychologically a woman, in this case. So in effect, he says there is an implicit limitation on paragraph 21 of Richards, where Richards says, up to member states to determine the legal conditions for recognition of an acquired gender. There's a limitation on that. Those conditions, says Lord Panic, can only refer to whether a person is medically and psychologically a woman. He also says then, second way in which he puts the case, that the marriage condition is unjustifiable. But, as he made clear, the reason he says it's unjustifiable is because it doesn't relate to whether a person is medically and psychologically a woman. So we say these are essentially it's essentially the same point, the same issue of justifiability. And of course we respond, well, the marriage condition is justifiable so as to protect the institution of marriage, and then he replies, but you don't have to do that. You can have a different regime for pensions. You can have your regime for marriage, but no need to apply the same rules to pensions. So I'm going to treat his submissions as really collapsing into a single issue of justifiability. And I presumably it will be accepted that there wouldn't be an implicit limitation on paragraph 21 of Richards if the marriage condition were justifiable. It's all the same. It's all the same point. Now, we respond to this criticism on justifiability in two stages. The first stage is we say that there is simply no at-large question of justifiability to be answered. We say paragraph 21 of Richards means what it says. Member states can determine the legal conditions for recognition of an acquired gender. And in paragraph 51 and following of our printed case...
I think you accept that there are limits to that, don't you?
Paragraph 51 and 52 of our printed case is where we say what the limits are. And essentially, paragraph 52, we accept that there must be some minimum standards, but we say that the minimum standards are to be found first and foremost in the ECHR. As we know that EU law at least respects the principles to be derived from the Convention, and we know that in this line of case law, the Court of Justice has regarded as highly significant a finding of the Court of Human Rights against the member state, CKB, where the Court of Justice relied directly on Goodwin and found the position in UK law to be in breach of the Convention. So Convention rights are a minimum standard, we accept that. And we also accept that, as one would expect in relation to this directive, that conditions which are laid down to determine, or for the purposes of determining eligibility to benefits falling within the directive cannot discriminate on grounds of sex, directly or indirectly. And we submit that they don't, that this particular condition doesn't discriminate directly or indirectly. Now,
so do you reject the argument that the proper comparator for discrimination purposes is a person born a woman?
No, I don't reject that. I know I was accused of being a dinosaur as a result of certain paragraphs of my case and going back to an argument which was rejected in P&S. But we do actually come on in paragraph 61 of the case to deal with the question of whether there is, in this context, discrimination on grounds of gender reassignment in comparison with a person who was born in that gender. So in paragraph 61, as we then understood Lord Panic's case, we say that he doesn't allege that the marriage condition discriminated on grounds of sex in the Richards P&S way, treating unequally a person of an acquired gender as compared with the person who was born in that gender.
I must have misunderstood him because I thought that was precisely...
Well, indeed, no, and I now understand that it is his case, but fortunately we went on to say why it was wrong. And I will come back to that, if I may, in a moment, my ladies. But I do accept that there is an argument to be had with that comparator in mind.
Who is the relevant comparator to the appellant?
Well, on the Richards line of argument, or on Lord Panic's line of argument.
No, but on your case, who is the relevant comparator?
Well, on our case, there is, so far as direct discrimination is concerned, there isn't. There by definition is no direct discrimination in this case.
Well, you say that is because Strasbourg says the situation of people in the appellant's situation is not sufficiently similar to the situation of others, as I understand it. You're taking the Savalainen case approach. So you say that there's no discrimination because they're not sufficiently similar. But you are faced with the fact that Luxembourg has said that there is discrimination.
Yes, well, Lady, first of all, yes, I do rely on Hämäläinen, but for these purposes. But I go further and say not only that's what they said, but also that they were right for a number of other.
Of course you do. Yeah.
Of other reasons. Well, shall I take discrimination then now? If I go to paragraph 62 of the...
You have to say, don't you, that her position is comparable to that of somebody who was born male and remains male and is effectively a male cisexual, because, you say, she's not regarded as having changed gender, and because she's not regarded as having changed gender, the comparable is male.
Yes. Well,
that has to be your argument, doesn't it?
Yes. Well, I think my argument is that there is no comparator. There is no comparator who is in a relevantly similar situation, either the male or the female. But it does. I accept it does logically follow from our argument that this is a condition, which is a prior condition to the appellant being recognised as female. And therefore, if she is to fall into one camp or the other, it's the camp that my lord put to me. But our argument is that there is no comparator with reference to whom a direct discrimination complaint can be brought.
You say having an unmarried status is necessary to being a woman.
I'm sorry, my lord.
You say having an unmarried status is necessary to her being a woman.
Yes.
And since she is not, since she's still married, ergo she can't be a woman. Therefore, she's to be compared with other men.
Well, yes, as very much an alternative to my primary argument, which is that there is nobody in her position is sui generis. There is no proper comparator at all, and that comes back to the point that I made earlier that these are legal conditions which apply to only one population. They only apply for the purposes of determining whether a transsexual should have their new gender legally recognised, and this is a particular aspect of discrimination law which is carved out by the Court of Justice. Member states are instructed to lay down conditions for transsexual persons, but they are conditions which necessarily can only meaningfully apply to persons who are undergoing or have undergone gender reassignment. So that is paragraph 62 of our case is the Hämäläinen line of argument. So a transsexual person is not, for these purposes, in a comparable position. The marriage condition was one of the conditions laid down by national law for the legal recognition of a change of gender. It could only apply to transsexual persons. And we refer to Hämäläinen, and we refer to Parry. And we then say in paragraph 66 that there is, in any event, no unequal treatment between a woman whose gender was acquired and a woman who was born in the female gender. If that's the comparator, the effect in substance is to place both women in the same position as regards pension rights and the right to marry. And indeed, it's at 67. It's necessary to have the marriage condition so as to avoid giving preferential treatment to a woman whose gender has been acquired. But if I could put the direct discrimination or the no direct discrimination argument in a slightly different way, every one of the conditions in the Gender Recognition Act is a condition for recognition of change of gender, is a condition which only applies to transsexual persons. So if the marriage condition is directly discriminatory, then so is every other condition, because none of them are applied to persons who are born in the female gender or born in the male gender, whatever the case may be. And of course, this is direct discrimination we're talking about here, which I presumed, or Panic would say, is not even capable of justification. There is direct discrimination.
Well, I was going to ask you that as a result of the way in which you were encapsulating his case, because what he is saying is that there is direct discrimination between a born person and an acquired person for the purpose of access to pensions, which is the only purpose with which we're interested, because that's what the directive's all about.
Yes.
As I understand it, that's what he says. It's perfectly simple. And I don't...
Yes, he is saying that, and I, as I said, I understand the logical conclusion of his argument to be that no issue, although it's all under the rubric of justifiability, in fact, he would say that there's no possibility of justification by the Secretary of State, and that.
But when he says, this woman, my appellant, is being discriminated against directly in comparison with other women, that begs the question, possibly, Mr. Koppel, of in these extremely sensitive and difficult situations, when does the law say the appellant does become a woman.
Well, indeed, and certainly that I hope was what I was trying to say in answer to my Lord Toulson, which is that we are dealing with this a prior stage, with a prior stage of whether somebody in the appellant's position has become a woman and is in that comparable position or not. The other way of, perhaps a further way of putting this point on direct discrimination is, perhaps I've already done so in some way already, is to say that, well, if this is direct discrimination, it is a form of direct discrimination which is expressly permitted, indeed required by the Court of Justice. Member states have to lay down these special conditions which only apply to transsexual persons for the purposes of determining whether their new gender should be recognised. So it is far from this being discrimination contrary to the directive, it is discrimination which is mandated by the directive. You must have these conditions. Now, there are minimum standards, yes, but one must have a set of conditions which are only applicable to transsexual persons. So, for all those reasons, we say that this sort of simple shortcut, direct discrimination, simply doesn't arise, and if it did arise, well, one is into paragraph 66 and 67 of our case, which is far from there being less favourable treatment. This rule is necessary to prevent there being more favourable treatment of the person in the appellant's position. Now, so far as indirect discrimination is concerned, my learned friend made references to the directive and the reference to marital status in Article 4.1 of the directive, which is on page 636, tab 15 of volume 1. And we submit that there is nothing in the language of Article 4.1 which suggests that there's anything special about marital status which gets one out of the usual questions of whether direct or indirect discrimination, as we're now discussing, will arise. So what it says is there should be no discrimination whatsoever on ground of sex, either directly or indirectly, and one could stop there. But in particular, and perhaps bearing in mind the sort of practices which were prevalent in the workplace in that era, in particular, with reference in particular to marital or family status, as one did have practices with reference to marital status which discriminated against women directly, in some cases, indirectly in others. But you still need to ask, is the particular rule in question indirectly discriminatory? Now, this rule, the marriage condition, is not indirectly discriminatory, and it would be a revolution in discrimination law if it were. Lord Panic relies upon statistics, and these are recently acquired statistics. There's been no debate about these in the courts below. They weren't tested in evidence. This is a new point for the purposes of this appeal, and indeed some of the statistics were only provided a couple of days ago.
Are you saying that all the statistics we've got over the last few years, I don't know whether you're aware of this new book that's just come out, Dr. Sherpa's book, on the legal status of transsexual and transgender persons, that he takes quite a wide, or the English chapter takes quite a wide look at the statistics. And if anything, Lord Panic has understated the ratio of male to females,
Yes.
rather than female to males.
Yes. Well, my Lord, we certainly accept that there is a disproportionate, there is a majority and perhaps a large majority of male to female applicants as compared to female to male applicants, and that may be, and as these figures weren't relied on previously, haven't been tested, we haven't had a proper chance to think about them, but there are reasons why that may be the case. It may well be, for example, that gender dysphoria is more prevalent amongst men than women. It may be that applications for gender recognition certificates are more likely to be made by male to female transsexuals rather than female to male because of the more generous financial benefits which are available to females, e.g. the state retirement pension. But my point on the statistics is they don't show the gender breakdown which it would be necessary to show in order to prove the proposition that Lord Panic is seeking to derive from them, i.e. the proposition that they have that the marriage condition at the time when it was in force in England, Wales and Scotland had a disproportionate impact on male to female as opposed to female to male. They aren't detailed enough. The only statistic he has for married applicants relates to 2014 to 15. The statistics on conversion of interim GRCs to full GRCs don't distinguish between interim certificates which were converted by people in a civil partnership as opposed to people in a marriage. And as you know, the marriage condition is also a civil partnership condition. It applies equally to people who are in a civil partnership. That must be dissolved before full recognition can be given. But whatever the statistics show, and let's assume they show that significantly more men than women apply for gender recognition certificates, that is not sufficient to establish indirect discrimination. Just because more of one sex than the other happen to apply for a particular benefit or a particular job does not mean that any condition laid down for that benefit, for that job, has a disparate adverse impact upon that sex. There must be something about the condition in question which is intrinsically more difficult for one group or the other to satisfy. Now that is made clear, and we've given you one reference to discrimination law, tab 7, page 416, which is the definition of indirect discrimination in the Equality Act, which is itself based on EU directives. And section 19.1, a person discriminates against another if he applies to the other a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic. For the purpose of subsection 1, a provision, criterion or practice is discriminatory if A applies or would apply it to persons with whom B does not share the characteristic, so it applies across the board to everyone. It would or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it. So you have a condition for admission to the police force that you have to be 6 foot tall, say, applied equally to men and to women, but it puts a woman at a particular disadvantage because they're far less likely to be able to satisfy it than men. So simply because more men than women or more women than men are interested in a particular job, that doesn't establish indirect discrimination. You take another example. Take a job for which the pool of applicants is predominantly male. Coal miner, Supreme Court Justice, for example.
I was thinking of that myself.
And the fact that more men than women apply for the job does not mean that any condition which is set for the job is therefore indirectly discriminatory against men and has to be justified. Simply that's the revolution in discrimination law that Lord Panic seductively asks you to endorse. I do have some authority on this. I don't think it's necessary for me to go to it. It's simply plainly and obviously wrong. And in the present context, there is nothing about the marriage condition which makes it intrinsically more difficult for men than women to satisfy. There is a procedure laid down which applies to both sexes. Both sexes can exploit it, so as can use it so as to obtain the interim certificate, and then a full certificate. There is nothing about being married which is more difficult for men to change than for women. So, this is not direct discrimination on the P&S Richards type analysis. The reasons I've given, it's not indirect discrimination. It's not direct discrimination on the traditional male-female analysis, because the marriage condition applies to everyone, as we know. So one doesn't get into objective justification under this head. So that's one minimum standard. The other minimum standard, we say, is human rights law, convention rights, and we are content in that context to rest on Hämäläinen and the clear and consistent line of authority from the Strasbourg Court, which preceded it. There was Parry. There was a Scottish case that came out on the same day as Parry, called R&F. From Strasbourg, there's Hämäläinen in the chamber, and there's Hämäläinen in the Grand Chamber. Clear and consistent line of authority. No attempt by the appellant to distinguish this line of authority on the facts. There isn't anything about the Finnish law that's intrinsically different, or anything about the circumstances of the different applicants that's intrinsically different. Lord Panic simply and frankly submits that the large majority in Hämäläinen got it wrong, and the minority got it right. For what it's worth, if I have to go that far, we would say the minority in Hämäläinen failed to give sufficient weight to the societal interest in Finland of preserving the institution of marriage as they regarded it, and they gave undue weight to the degree of inconvenience to the applicant. But I don't need to say that, because the majority of the Grand Chamber said that in Hämäläinen. And the proposition that a marriage condition is justifiable as a matter of human rights law gets me, we submit, a long way towards satisfying any further requirement of any further or wider requirement of justification which may arise under EU law. And that is because, as we've seen from the authorities, the Court of Justice takes its cue from Strasbourg in this context. Case after case relies upon the position as determined by the Court of Human Rights in Strasbourg. So, insofar as I have to go further and justify the marriage condition, I then have two further stages to my argument. The first stage is to invite you to look at the context in which this issue of justification arises, and that's issues like the margin of appreciation or margin of discretion given the particular issues which arise. And then secondly, against that background, in that context, I will address the points which Lord Cannick has made. So far as the context and the margin of appreciation is concerned, we've seen from Hämäläinen the way that the Strasbourg court approached the margin of appreciation, the lack of consensus, the difficult questions of social policy, and of course I accept that international law margin isn't directly applicable in this court, but the same or very similar considerations which give rise to that broad international law margin also apply, we say, in the domestic court and in the CJEU, so as to dictate that the CJEU, will be extremely reluctant to intervene against legislation which has the character of the marriage condition. So in the domestic courts, it has consistently been held that the sorts of issues raised in this case are matters of social policy which are best determined by Parliament, not by the courts, and also that marriage is a particularly sensitive area where clarity and certainty are particularly important. And I need to show you two cases on that. Bellinger, please, tab 10 of bundle 1. And this is page 458, the pre-Gender Recognition Act case in which the House of Lords made a declaration of incompatibility of the Matrimonial Causes Act, having found that English law did not recognise a marriage between two people who were of the same gender at birth. Paragraph 32 on page 468. Please, this is in the judgment of Lord Nichols, and I'll just stick to the paragraphs which are directly relevant for my purposes. Paragraph 32, Lord Nichols says that the circumstances in which and the purposes for which gender reassignment is recognised are matters of much importance. These are not easy questions. The circumstances of transsexual people vary widely. The distinction between male and female is material in widely differing contexts. The criteria appropriate for recognising self-perceived gender in one context, such as marriage, may not be appropriate in another, such as competitive sport. And he goes on in paragraph 36 to say that the House of Lords should not accede to the submissions made on behalf of Mrs. Bellinger that her marriage ought to be recognised, because it would necessitate giving the expressions male and female in that act a novel extended meaning, that a person may be born with one sex but later become regarded as a person of the opposite sex. This would represent a major change in the law, far-reaching ramifications, extensive inquiry, and so forth. Questions of social policy and administrative feasibility arise at several points, and their interaction has to be evaluated and balanced. The issues are altogether ill-suited for determination by courts and court procedures. They are preeminently a matter for Parliament, the more especially when the government, in unequivocal terms, has already announced its intention to introduce comprehensive primary legislation on this difficult and sensitive subject. Paragraph 41, Lord Nichols discusses the relevance of surgery to gender reassignment. Paragraph 42, these are deep waters. Plainly, there must be some objective, publicly available criteria by which gender reassignment is to be assessed. If possible, the criteria should be capable of being applied readily so as to produce a reasonably clear answer. Parties proposing to enter into a marriage relationship need to know whether the marriage will be valid. Other people need to know whether a marriage is valid. It has legal consequences in many directions, including social security benefits. There must be an adequate degree of certainty. Otherwise, as the Court of Appeal observed, the applicability of the law to an individual suffering from gender identity disorder would be in a state of complete confusion. And finally, just on the following page, 471, paragraph 44, he says further, the House is not in a position to give guidance on what other preconditions should be satisfied before legal recognition is given to a transsexual person's acquired gender. Some member states of the European Union insist on the applicant being single or on existing marriages being dissolved. Some insist on the applicant being sterile. Questions arise about the practical mechanisms and procedures for obtaining recognition of acquired gender and about the problem of people who revert to their original gender after a period in their new gender role. So there's a recognition, we would say, of the intrinsic link between legal recognition of acquired gender and impact on existing marriages. And 46, there's a particular comment on the institution of marriage. Even in the context of marriage, the present question raises wider issues. Marriage is an institution or relationship deeply embedded in the religious and social culture of this country, deeply embedded as a relationship between two persons of the opposite sex. And 46, hardly needs saying, this approach would involve a fundamental change in the traditional concept of marriage. Now, the reason why I take you to this is partly to show you the general approach which we say the courts have taken, should take to the sorts of issue which arise in this case, but also to draw your attention to the fact that if Lord Pannick is right, then the courts will be invited to depart from the Gender Recognition Act on a case-by-case basis. This case is about state retirement pension. The argument is no need to apply a marriage condition to state retirement pension. But if that's right, well, there will be other contexts in which people will also say, no need to have a marriage condition, I should be able to have this, that, or the other benefit under this, that, or other provision of EU law or the convention without reference to a marriage condition. And the courts will be invited to decide on a case-by-case basis whether the individual's new gender, acquired gender, should be recognised. And that, we would say, puts us squarely in the position that the House of Lords was in Bellinger, and where Lord Nichols said firmly, this is really not for the courts. We need clear lines drawn by Parliament.
Can you give us a concrete example where the same issue might arise?
Well, for example, Schedule 5 of the Gender Recognition Act, which is that dealing with benefits and pensions, deals with a whole range of different benefits and pensions. It starts at 255. Widowed mother's allowance, widow's pension, widowed parents' allowance, incapacity benefit, different categories of retirement pensions. There's guaranteed minimum pensions under occupational pension schemes at 259. One doesn't want to go there. That's within a fairly narrow penumbra going out from the centre of where we are. But in principle, it is any right which the individual claims as a matter of EU law. Let's just take EU law for the moment, and there'll be different rights under different directives, but same principles. Applying KB, applying Richards. If Lord Pannick is right, then for each EU law right which is claimed, and where it may make a difference whether the gender is one or the other, then there will be an argument in each case as to whether the marriage condition is sufficiently important in that particular context, or as to what other conditions laid down in the Act may not be sufficiently important to be applied in that particular context. So I don't need to go further than Schedule 5, but but there would be a range of other possible arguments. And that does open up exactly the sorts of arguments that the House of Lords wish to close down in Bellinger. And we would say legal certainty, which is really what this is all about. Legal certainty is as much a principle of EU law as it is of domestic law. And the idea that the Court of Justice would be insensitive to that sort of condition, we say must be wrong. So that's Bellinger. Can I also show you quickly a further authority which is not in the bundles, which is A against Chief Constable? I think we need to hand that up. Which is the
That's
other...
the one I should remember,
well,
isn't it?
Indeed. Well, I was concerned that I might be asked about it if I didn't show it to you, but yes, we'll hand them out. Sorry, I'll try and find my own copy. So this was a case of alleged unequal treatment in the matter of employment of a police constable, and it's really the first few lines of the head note. In March 1998, the applicant, a male to female transsexual, was rejected for appointment to the police force because as a transsexual she would not be able to carry out all the duties of a police constable, could not satisfy the requirement in PACE that personal searches of detained persons be carried out by a constable of the same sex as the person searched. And there's a finding by the House of Lords that there had been direct discrimination, essentially on P&S grounds, against the constable. And so far as the bits that I wanted to refer you to, Lord Bingham, please, at paragraph 15. He says in reaching his conclusion in favour of the applicant, he doesn't, paragraph 12, I do not intend to question or derogate from the very recent decision of the House in Bellinger, affirming the decision in Corbett. The House affirmed that decision not because it was insensitive to the hardship which the rule in Corbett strictly applied could cause, nor because it was unaware of the criticism to which the decision had been subject, nor because it ignored the Strasbourg Authority on transsexuals. It did so because, alive to the wide ramifications of departure from the established rule, it regarded the field as one calling for comprehensive legislative reform and not piecemeal judicial development. I've no doubt the decision was wholly correct. There was a prompt legislative response to it, but the case concerned marriage, perhaps the most important and sensitive of human relationships. It lacked community dimension, so there's no need to consider P&S. And it's the points that we rely on are the wide ramifications of departure from the established rules now in the Gender Recognition Act, and marriage, the most important and sensitive of human relationships. And my lady also dealt with Bellinger in her judgment at paragraph 52.
So could you just read 37, the first sentence of 37?
So it is remarkable that in each of the cases, this is my lady, in each of the cases brought by trans people under the ECHR, the European Commission on Human Rights has found a breach of the relevant article, whereas the European Court of Human Rights has been slower and more selective in taking that view.
Thank you. Paragraph
51 As to domestic law, there might be good policy reasons for distinguishing between the different purposes for which the decision in Corbett may be invoked. And that's the decision that a man is a man at birth and a woman is a woman at birth. Perhaps resonates with my learned friend's submissions here. There might be good policy reasons for having different rules in different contexts. But you say marriage can readily be regarded as a special case. True, it's perfectly possible to have a valid marriage between two people who can have children together. Also true, the fact that marriage distinguished between husband and wife cannot be a conclusive argument against the marriage of two people who for all practical purposes are of opposite sexes, but marriage is still a status good against the world in which clarity and consistency are vital. In England, the Church has a role in celebrating marriages. Special exceptions have to be made. Scarcely surprising that this House in Bellinger held that these difficult questions of definition, demarcation and impact upon others were for Parliament rather than the courts to decide. And it's the Bellinger point, but it's also my lady's note that marriage is a special context where clarity and consistency are vital. And what you're being invited to do is to rule that a marriage which would effectively be invalid for some purposes should be valid or should be regarded as valid and not as an obstacle for other purposes.
I do have some trouble with that argument. The point being made there is that it is important to know who is married and who is not, who is validly married and who is not. As I understand the appellant's case, it isn't predicated on any challenge to the validity of the marriage. It is predicated on a challenge to the validity of requiring somebody to be unmarried for the purpose of recognition, which is not a...
Well, we submit one simply can't draw a firm line in the way that you seek to do, because what is being suggested is that a person should be recognised as having acquired a new gender even though they are still married.
Yes.
For certain purposes, albeit for other purposes that wouldn't be the case. And one is moving away from clarity and consistency in favour of a case-by-case, somewhat blurred line.
But it's the clarity and consistency of the gender recognition, the gender reassignment recognition that would be blurred, not the clarity and consistency of marriage law. That wouldn't be blurred.
Well, save that in certain circumstances for certain purposes, you now have two persons of the same sex, or whom the law regards as being of the same sex for certain purposes in a marriage, when that is otherwise not.
It isn't really what's happening. What would be happening would be that somebody who was married was nonetheless able to claim a retirement pension at the age of 60.
Well,
that's what it's about.
It is somebody being able to obtain, somebody being able to have the law recognise their acquired gender, even though they are still married.
I mean, your complaint is for the purpose of the marriage, they'd remain a man. For the purpose of pensions, they'd be a woman. And you say this is utterly incoherent.
Yes. No, I'm grateful. I mean, that's the blurring of the line. There are for some legal purposes they're one sex, and for other legal purposes they're another.
Yes, and you say a member state is entitled to legislate to have bright line rules for all purposes.
Yes. So that's A and Chief Constable, and so I've still on the general context, the margin of discretion, we have Hämäläinen, we have the domestic cases, which I say show a clear policy in favour of leaving this to Parliament, in favour of clear lines, and the Court of Justice taking its cue from Strasbourg, and also, I should say, taking note of the extent to which there is a consensus amongst the member states of the EU. And that is of some significance, because the Court of Justice, of course, rules on the law, rules on the application of the directive as it applies in each and every one of the member states. And as we saw from the survey in Hämäläinen, most of the other member states aren't anywhere near as advanced as the UK in terms of gender recognition, whether for the present or other purposes. So, against that background, we have various points on justifiability, which are set out in our written case, that I'll just draw your attention to. Beginning at paragraph 44, please. And the submission which we're saying in paragraph 44 is not correct is the submission that conditions laid down for the purposes of legal recognition of an acquired gender can only be medical or psychological conditions. At the point at which we were drafting the argument, it was surgical conditions, but the same, much the same points still apply. And we say, paragraph 44, Richards, paragraph 21, there is simply no limit, no attempt to define or limit the conditions that member states are entitled to put in place. And that's either expressly or by necessary implication. Paragraph 45, we say one does have to look at the origins of the decision in Richards and the previous cases. Article 4.1 of the directive, anti-discrimination in relation to certain state benefits. It doesn't regulate gender reassignment per se. And we say it would be surprising if one could get the extent of the detail and the detailed prescription of the conditions for legal recognition that Lord Pannick seeks to derive from the directive. We submit that the approach taken in Richards is entirely understandable, that what is prohibited by the directive is having no possibility, no ability to have your change of gender legally recognised. And that is simply not the case here. And then 46 is our points about incursions into the right to marry. I've made my points on that. 47 refers to KB, going back to then paragraph 48, going back to Goodwin at paragraph 103. And then paragraph 49, we draw attention to the submission of the UK government in Goodwin at paragraph 96 that legal recognition of gender reassignment would potentially invalidate existing marriages and leave transsexuals and their partners in same-sex marriages. The Court of Justice in KB adopts Goodwin without qualification, and we say should be taken to have accepted paragraph 103 to its full extent. It didn't suggest otherwise. But Goodwin, KB, Richards, we say all these authorities do accept that there is an intrinsic link between legal recognition of acquired gender and validity of existing marriages. They aren't two entirely different and separate things, as my learned friend suggests, and one simply can't say that the directive is only concerned with one and not with the other. The other points on justifiability that I wanted to refer you to are from paragraph 75 of our case onwards. And paragraph 75 is that just as in Hämäläinen, the effect of the marriage condition is significantly tempered in the appellant's case, indeed in all similar cases, by the availability of civil partnerships under the Civil Partnerships Act. So this is by no means within the category that one sees delineated in the Court of Justice judgment. So it's impossible to obtain legal recognition. You're unable to obtain legal recognition. There is an equivalent institution which is available instead of marriage, and a relatively simple procedure for taking advantage of it. And finally, as far as our case is concerned, paragraph 79, where we refer to the ruling of the Court of Justice in Richards. This is on possible limits to the temporal effect of its judgment, where it said at paragraph 43, in this case, the entry into force of the 2004 Act on 4th April 2005 is liable to lead to the disappearance of disputes such as that which gave rise to the case in the main proceedings. So having set out the provisions of the Gender Recognition Act, that being a case that was only about entitlement to pension, not about marriage, not about anything else, the Court of Justice then says this is all going to be resolved in the future by the Gender Recognition Act, and that must be, we submit a finding in our favour and not in favour of the appellant. So I then come to address Lord Panic's point that Parliament should have given legal recognition to the appellant's acquired gender for the purposes of a claim to state retirement pension, whilst preserving the marriage condition for the purposes of recognition for other reasons, including marriage. And what I think he is challenging, and it's somewhat unsatisfactory where you're being invited to disapply provisions of domestic legislation. What I think he's now challenging is Section 9 of the Gender Recognition Act. And one sees that on page 232, tab 4, page 232. Section 9.1, where a full gender recognition certificate is issued to a person, the person's gender becomes, for all purposes, the acquired gender. So that if the acquired gender is the male gender, the person's sex becomes that of a man, and so forth. And that is the bright line which Lord Panic says should not apply in the case of state pension, because for those purposes, the gender recognition certificate should not be necessary for the recognition of the acquired gender. So the Act draws a line in the sand upon the issue of a gender recognition certificate. For all purposes, in law, the new gender is recognised. It doesn't apply to things like issuing of passports and driving licences, where it's not a matter of law but a matter of administrative practice. But in law, and including for the purposes of social security law, in law, your gender changes upon the issue of a gender recognition certificate, and Section 9.2, it only changes for the future and not for the past. And that is the bright line which we say the appellant is now seeking to blur. Page 255, Schedule 5, paragraph 1, this schedule applies where a full gender recognition certificate is issued to a person, well, I suppose that Lord Panic would have you do surgery to this schedule as well, so that it didn't necessarily apply where a full gender recognition certificate is issued. It could apply in other circumstances as well, where the certificate was not issued. But somehow this would have to change as well, and would have to change not just for pension but for other purposes if the appellant's argument were to be accepted.
This is not a point that's been developed, but I'm not sure that that's necessarily right. It may be that the challenge is to the social security legislation, that's what he says, taken with the GRA at the time as it then was, produces the problem. But
Yes.
addressing, tackling the GRA part of it is not the only way in which the matter could have been met. His complaint is not that marriage law should be as it was, but that pension entitlement should be limited in the way that it was.
Well, Lord, yes, I can see that. At the moment, the words man and woman in the social security legislation mean man either at birth or subject to a gender recognition certificate, whereas he would say that, I suppose that, or he could say that man ought to be read as
Well, or not necessarily, because the person in the appellant's situation was entitled to a gender recognition certificate. It would be an interim one, not a full one.
Yes, so I suppose
his end would be achieved if he said that for the purposes of social security legislation, the interim gender registration certificate should be all the social security law required.
Yes, that it could be done in that way as well. Like I say, whichever way it's done, and I see the different ways. There's a blurring of the lines, but I suppose I'm also making the point that you haven't had detailed argument on which bits of the domestic legislation ought to be got rid of and which not, because simply the case hasn't been put in this way before.
As a matter of interest, we don't have, do we, I think, in the bundles, the form of gender registration certificate. It doesn't appear in the Act to be prescribed in any schedule. I only inquire for this reason. It's not imperative, but I think the way the case is put on the other side is that the issue of an interim certificate is conclusive evidence, demonstrates that the objective criteria have been met. His objection, her objection, is to the additional status requirement.
Yes, and I accept my Lord's point that one could change the legislation in that way and say that an interim certificate was sufficient for these purposes, but perhaps not for other purposes.
The only difference, as I understand it, between an interim certificate and a definitive certificate is it relates to the marriage condition. There's no other purpose for which the difference matters under the scheme. Is that right?
Yes, the marriage or civil partnership condition, yes. So, should the domestic legislative scheme be changed with reference to the directive in order to permit legal recognition of acquired gender for the purposes of state retirement pension, where it would not be conferred for other purposes, is the question. And I've made my point that once one moves away from the bright line, there are going to be other contexts in which similar arguments can be maintained. Why do we say that Parliament was entitled to lay down this particular bright line? First of all, there's the context point, the wide margin of discretion in this particular area, having regard to, for example, the lack of consensus, and I've referred to as already the lack of consensus amongst other contracting states or member states of the EU. This is a par excellence matter of social policy, where the Court of Human Rights affords a broad margin of discretion, and the Court of Justice takes its cue from the Court of Human Rights. Secondly, we say that the case law points in the other direction, points in our favour, and that's the consistent references in the case law to it being for member states to decide what conditions to lay down. Goodwin, KB, Richards, a case about pension, not about marriage, which makes the same point, and no suggestion in any of the cases that a member state has to distinguish, discriminate, and have different rules for legal recognition for some purposes, but not for others. And thirdly, we say, quite apart from the authorities, that this is an obvious case for a bright line rule. The issue of whether somebody is to be regarded in law as a man or a woman, we say is par excellence the sort of question which Parliament was entitled to regulate with clarity, with certainty, with a bright line applicable across the board. It's hard to imagine, we would say, a more obvious case where certainty is necessary, and where one ought not to have different legal regimes for different benefits, for different claims. So those are that is in short what we say about the argument that one ought to have a different regime for the purposes of state pension, and we rely. We say we are squarely within the Bellinger.
Yes, you've said that a few times.
I've said that. I think, subject to anybody telling me differently, beside or behind me, I think those are my submissions.
Thank you very much indeed, Mr. Coppell. Mr. Lask?
Thank you, my lady. I have nothing to add.
No panic.
My lady, at the outset of his submissions, my friend said in answer to your ladyship that he agreed the directive does have direct effect. He then said that the appellant should have sought to obtain a full certificate. That argument has not previously been advanced by the Secretary of State in the first tier tribunal, in the upper tribunal, or indeed in the Court of Appeal. And I say, if that point is seriously being relied upon, the appellant was entitled to do what she did, to bring her claim in the tribunal, because her contention is that she's entitled to be recognised as a woman at age 60 under the directive for pension purposes. That is her claim. It's either a good claim or it's a bad claim, but she's entitled to pursue it in the proper place before the tribunal. Now, there's no dispute from us that it is in general for the member state to determine the conditions under which legal recognition is given to the change of gender of a person who has undergone gender reassignment. And that's what Richards says at paragraph 21. But that begs the essential question: what are the limits? that are imposed on that discretion that the state enjoys. And I don't think there's any dispute between the parties that it is a limit on that discretion that the state may do nothing that amounts, properly analysed, to direct sex discrimination or indirect sex discrimination. So my friend is not contending for a carte blanche. He recognises there can be no direct sex discrimination and no indirect sex discrimination. Indeed, his written case says so, paragraph 57. And our case is either there is direct sex discrimination here or there is indirect. Now, on direct sex discrimination, our case, as my lady the Deputy President put to my friend, our case is very simple. We do say that for the purposes of direct sex discrimination, the proper comparison in this context, by which I mean gender reassignment, the proper comparison is with the treatment of a person born female. And we have strong support for that submission, I say. And we have strong support because that's what the Advocate General says in terms in Richards, paragraphs 44 and 45, in a case that's identical to the present in all material respects. And it's what the court says in Richards, paragraphs 29 to 30. Now, Strasbourg, again, my lady put this point to my friend, Strasbourg takes a different approach. Strasbourg says there is no relevant comparison. And that's my friend's argument. My friend's argument this afternoon is there is no relevant comparator here. But I respectfully submit that that submission is inviting this court to reject the Luxembourg case law. And that case law, with great respect, is binding. It's binding on this court. The court is obliged to follow Luxembourg. Now, if that's right, and the proper comparator is the woman who is born female, then we say that the crucial point is that a woman who was born female is entitled to a state pension at the age of 60, irrespective of marital status. Her marital status is simply irrelevant in the pension context. It's simply irrelevant whether she wants to marry, whether she is married. It has nothing to do with receipt of a state pension. That is our direct sex discrimination argument. Justification doesn't come into it. If necessary, I add to that simple point that to impose a condition which doesn't relate to whether the appellant is medically and psychologically a woman is itself to breach the principle that she, my client, is entitled to be compared with the woman born female. It's an irrelevant factor. That's our case on direct sex discrimination. In my submission, my friend simply has no answer to it other than to invite the court to depart from what Luxembourg has said. Indirect sex discrimination. Now, there's no dispute, I think, on the statistics that the marriage condition mainly affects women in the sense that the statistics show that gender reassignment is very predominantly a male-female phenomenon. My Lord Wilson put to my friend that, if anything, I was underestimating the social reality, and I, of course, accept that. My friend said, incidentally, he had a half-hearted complaint, if I can put it like that these statistics had not previously been relied on. Well, they are the official statistics. They're not contentious in themselves. I appreciate my friend's entitled to draw attention to their limits, but they are the official statistics. Now, if it's right, and it is, that gender reassignment is very predominantly a male-to-female phenomenon, I mean, it affects people who become women far more than those who become men, then what we're concerned with here is a marriage condition. We're not concerned with any old condition. We're concerned with a marital condition. And the terms of Article 4 of the directive make very clear indeed that the directive is particularly concerned with any question of potential indirect discrimination where there is a marital condition. And the statistics also show, if one needs it, that a marital condition affects far more male to female reassignment cases than female to male.
Yes, but Lord Panic, that's not enough, is it? The mere fact that something affects more of one than the other does not make it indirect discrimination unless it is more difficult for people in Group 1 to fulfil the condition than it is for people in Group 2.
Yes, I accept that in general, but we're talking about a marital condition. If one's going to adopt that approach in relation to marital conditions, one is removing, in my respectful submission, the intention of the directive, which is to allow marital conditions only to be imposed where there is justification.
Well, so you're saying that because of the reference in the directive to marital conditions, the point that Lady Hill has put to you as a necessary precondition of indirect discrimination is swept aside. Is that your position?
I'm not saying it's swept aside. I'm saying that the law proceeds on the basis that marital conditions are particularly vulnerable. And where one has here a marital condition imposed, then the court will be very reluctant not to require it to be justified.
But the vulnerability presumably arises from the historic disadvantage that women were in through the marital condition. I mean, the question still remains, does it not? Does this condition impact, does this condition create a higher hurdle for a man wanting to become a woman than for wanting to be recognised as a woman than it does for a woman wanting to be recognised as a man? And I think the answer is clearly not.
Well, I would quarrel respectfully with that, because the statistics do suggest that there are more people who begin as men who undergo gender reassignment who are married than people who begin as women who are seeking gender reassignment. That's what the statistics suggest. I entirely accept they're very small categories of persons, but that's what they suggest. And therefore, I'm inviting the court to proceed on the basis that gender reassignment, a marital condition, hits harder at those who end up as women than it does those who end up as men, because it is more likely that someone with gender dysphoria who begins as a man is in a marital state. That's the argument.
It affects more people, but it doesn't necessarily erect a higher hurdle.
No, but the question then is how does one define the nature of the hurdle? There's one authority that may or may not assist that specifically addresses marital discrimination. It's the only case I can find. Your Ladyship may be aware of others in the Luxembourg Court. It's Tuling. Tuling is Volume 2, Tab 20. It's in relation to Directive 79(7), and it's concerned with incapacity benefits, which were determined in part by marital status. And the court addresses the criteria for disparate impact, for indirect discrimination. This is tab 20, begins at page number 663. and the relevant passage is at page 687. And it's paragraph 13, where the court points out that a system of benefits in which, as in this case, supplements are provided for which are not directly based on the sex of the beneficiaries, but take account of their marital status or family situation, and in respect of which it emerges that a considerably smaller proportion of women than of men are entitled to such supplements, is contrary to Article 4.1 of the directive, if that system of benefits cannot be justified. And then the court goes on to say it appears from the documents before the court that according to statistics, a significantly greater number of married men than married women receive a supplement linked to family responsibilities. According to the plaintiff and the Commission, that results from the fact that in the Netherlands there are at present considerably more married men than married women who carry on occupational activities, and therefore considerably fewer women who have a dependent spouse. In such circumstances, a supplement linked to family responsibilities is contrary to Article 41 unless it can be justified. Now, that doesn't suggest in the context of marital discrimination, of a marital condition, and Article 4, that it's necessary to do more than point to the disparate impact. That's what it suggests. If there are other cases on this particular aspect of Article 4, then I'm not aware of them. But that's the authority.
Thank you.
I therefore say the question is justification, and what has to be justified under indirect sex discrimination is the refusal to treat the appellant as a woman for the purpose of the age at which she is to receive a state pension. Now, of course, it is right that marriage law, as my friend emphasised, is a sensitive subject, and I don't dispute that for a moment. But the point of my submissions on justification is that, in indirect discrimination, the point is that the issue before the court, this court, concerns social security law. It does not concern marriage law. And I respectfully submit that the error in my friend's submissions is a failure to recognise the distinction. The directive is simply not concerned with recognition as a woman for the purposes of the law of marriage. And just as Miss Richards and Miss Timbrell were recognised as women for the purposes of the directive, whether or not they were married, they in fact were, I say this appellant has the same right under the directive because of its direct effect. Now, my friend drew attention to the judgments, the speeches in the appellate committee in Chief Constable of West Yorkshire Police and A. And could I invite the court, please, to go back to that? Because my understanding of the Deputy President's speech in the A case is that your ladyship was making precisely this point, that it all depends on the context. And can I invite this court to pick up my lady's speech, speaking for the court, because Lord Steyne agreed with your ladyship, as did Lord Carswell. And your ladyship, at paragraph 50, I'm looking at page 70, your ladyship said, and this is an employment case related, if one's looking at sensitive subjects, this is a sensitive subject. If one goes back to the head note, the applicant is a male to female transsexual who wants to join the police force. And she is rejected because by reason of gender reassignment, she wouldn't be able to carry out all the duties of a police constable, in particular personal searches of detained persons. So she complains of sex discrimination, And the argument from the West Yorkshire Police is no sex discrimination for a variety of reasons, one of which is the whole series of cases, beginning with Corbett and Corbett, the April Ashley case, and culminating in Bellinger. And your ladyship at paragraph 50 says, in your ladyship's view, the answer to this appeal must turn upon the rights of a trans person under the Equal Treatment Directive rather than upon domestic law or the impact of the Goodwin decision. And then at 51, as to domestic law, your ladyship recognises there might be good policy reasons for distinguishing between the different purposes for which the decision in Corbett may be invoked. Marriage can readily be regarded as a special case, and your ladyship deals with that. At 52, your ladyship points out that the house in Bellinger was concerned only with capacity to marry and with the meaning of the words respectively male and female in section 11C of the Matrimonial Causes Act. These presuppose two clearly distinguished gender. It's less clear why mutability of birth gender for marriage purposes should apply for all other purposes, in particular to criminal offences. Most of those distinctions are of historical origin. And then your ladyship refers to Goodwin in 53, and at 54, and this is the point, however, this clearly does not preclude a decision that the directive, there the Equal Treatment Directive, is indeed to be interpreted as requiring that trans people be recognised in their reassigned genders for the purposes covered by the directive. And that's the point. And your ladyship returns to that point at 58, at the bottom of page 73, where your ladyship is very clear. This decision confirms the right of the trans person to be recognised in the reassigned gender, not only for the purpose of the direct enjoyment of community rights, but also for the purpose of the preconditions of such a right. And that's as far as it goes. And I therefore submit that that speech, on behalf of the appellate committee, supports our submission that it is perfectly proper as a matter of law for this court to recognise the rights of the gender reassigned person for a specific purpose and only for that specific purpose under the relevant directive. And for this court so to recognise says nothing about other areas of law in respect of which the directive does not apply. The law remains as it was, and it has no, a judgment in my client's favour has no effect other than in relation to her status for the purposes of the directive. My friend expressed concern that if we are correct, courts will be asked to address gender recognition, as he put it, on a case-by-case basis. But it is, I suggest, very difficult to think of any example other than that based on the 60 to 65 age difference. Other rights are not gender, other legal rights are not gender discriminatory. If they are...
They're not anymore, are they?
No, they're not.
I was thinking when we were looking at Schedule 7, widows' pension and widow mother's allowance, that whole series of benefits, did used to be gender-specific and would have raised some very interesting conundra in this particular situation.
But they are parasitical on the 60-65 distinction. They're not? Well, to the extent, but they're under the directive. To the extent that they are under the directive, then, and to the extent that it mattered whether or not the claimant is male or female, then the same issue would arise, I suppose, in the context of survivors' benefits.
Well, particularly, I'm sorry, this just come into my head and it probably needs thinking through. But those benefits used to be only available to widows,
Yes,
i.e. married women.
yes.
So is somebody to be treated as a woman for that purpose, but also a married woman?
That's more complicated.
That's more complicated.
Well, I
isn't it?
respectfully agree.
Yeah.
I agree.
So
But those cases, that is long gone, that form of, at least I hope it's long gone.
It's not long gone, but it is
It's
gone.
gone, and there's certainly no suggestion that there are any pending cases, nor I think would anybody be within time to bring such a case. And in any event, that would be a more difficult case than this one. And if necessary, a court will have to address that. But I say that's with respect, it's no answer to our contention, if we're otherwise correct, as to the impact of indirect sex discrimination. It certainly has nothing to do with direct sex discrimination. The other main theme of my friend's submissions was to focus on the human rights issue and the suggestion that Luxembourg has followed the Strasbourg jurisprudence. Of course, what is very striking, and it's why I invited my friend to read a passage, or rather a sentence, from your ladyship's speech in Chief Constable. It was paragraph 37. What is striking is that for many, many years, Strasbourg adopted a dismissive view, if I can put it that way, of rights claimed by those who had undergone gender reassignment. And what is striking about the Luxembourg case law is that the origin of this case law, P and S, was decided in 1996 at a time where there was no helpful case law helpful to the applicants in Strasbourg, and indeed a whole series of cases, some of which your ladyship refers to, that rejected claims under both Article 8 and Article 12. There was the Rees case, which is the only Strasbourg case referred to in P&S, if the court wants to go back to it, not now. In P&S paragraph 16, the Luxembourg court refers to the Strasbourg case of Rees, which rejected claims under Articles 8 and 12. Then there was Cossey, the Caroline Cossey case. Then there was Sheffield and Horsham. And then in Goodwin, the European Court changed its mind. It says so expressly in Goodwin at paragraph 73. It reconsidered the matter. So it is simply not right to say that Luxembourg has swum along after Strasbourg. It has not. P&S was a case decided long before rights were recognised in Strasbourg. In any event, and I've made this point already, the Strasbourg cases deal very briefly indeed with the sex discrimination arguments, and what they do is to say there is no relevant comparison. And of course, the Strasbourg cases deal with sex discrimination, and understandably so, because this is the Strasbourg jurisprudence. They deal with Article 14 as an adjunct to Article 8, and to a lesser extent as an adjunct to Article 12. Because, of course, in Strasbourg, the right to equal treatment is not a freestanding right. It arises in the context of another substantive right. And there was one passage in the dissenting minority in the Finnish case that I omitted to show the court in opening. Could I just go back to volume 2 of the authorities, tab 32? Because I did show the court at page number 1192 and 1193 the cursory way in which the Strasbourg court had rejected the discrimination argument, and the minority were very critical of that at page 1202. and at 1202, paragraphs 18 and 19, the minority explain why the majority's approach simply won't do, and I adopt that, but I won't take time on it now. Two final points, if I may. My friend said that I had not said much about the alternative of a civil partnership when I opened the case. That is because there is not much to say. A civil partnership requires the end of the marriage. One sees this from volume 1 of the authorities, tab 6, page number 404, which contains the relevant section of the Civil Partnership Act. At section 3, two people are not eligible to register as civil partners of each other if B, either of them is already a civil partner or lawfully married. And my client, the appellant, and her spouse, for religious reasons, are simply not prepared to end their marriage, and therefore they cannot have a civil partnership. There are also other minor disadvantages, but that's the main point. And finally, my friend said, finally, subject to any points that the court wants me further to address, my friend said I'd not explained what changes to the GRA I'm seeking. But, my lords, my lady, this is not a case under the HRA where I'm seeking a declaration of incompatibility. My lady, my lords, I'm entitled, I say, simply to seek a declaration. And that is, I think, the appropriate remedy if we're right. I'm seeking a declaration that for the purposes of Directive 79.7, the appellant was entitled to be treated as a woman on her 60th birthday for the purposes of a state retirement pension. That's not very elegantly drafted, but that's the point. That's what we're seeking. And it's completely unnecessary for me to invite the court, or indeed for the court to go through the GRA and amend it. If we are right, if we get that remedy, it would be entirely a matter for Parliament whether to take any further steps.
Isn't this basically a claim to the benefit?
Yes, it is. Yes, we're seeking back payment of her pension for the relevant 5 years.
In the event of, were you to be successful, isn't the remedy in order that the benefit be paid?
Yes, if the court prefers.
Whatever the tribunal could do.
Declaration.
Yes. Yes, a declaration that the appellant is entitled to the payment of a state retirement pension between the relevant 5 years, which would be as from when she arrived at her 60th birthday, which was the 31st of May 2008, and the date when she reached the age of 65, which is the 31st of May 2013. That would more than suffice.
And supposing we find ourselves confused, actually I should have put this point to Mr. Cobble as well, supposing we find ourselves not entirely satisfied as to whether you are right or he is right, is this a case where we should be referring the question to Luxembourg?
Well, I'm not encouraging the court to do that.
I've never met a litigant who did.
No. Well, sometimes... I better not say.
If one's convinced that one's going to lose, then...
Well, indeed. We would rather have a reference than lose the case, but that's obvious. But the reason why I do not invite the court to make a reference is because I say that the relevant criteria have been set out in Richards. This is not new ground. Richards addresses this very question, and the application of the principles, I say, is really a matter for this court, and therefore I'm not asking or inviting the court to make a reference, but if the court feels that it's appropriate to do so, then it will take its course. But this is not new ground. Can I just... We agree there's no application for costs because we're pro bono either way. Is that right?
There's a PCA.
Yes, I'm just checking with my friend. My understanding is that because we all act pro bono on this side, we are not applying for costs there's an agreement that we're not applying for costs against the Secretary of State if we succeed, and my friend is not applying for costs against us if he succeeds.
Yes, it's in paragraph 22
I'm
of
grateful.
the Statement of Facts and Issues.
Subject to the appellant's costs of disbursement, but I'm not sure whether that's dealt with. Maybe we should write in just to clarify the position either way in relation to that.
Well, that would be helpful.
Yes. Is there anything else? But subject to that, subject to any other points that the court wants me to address, those are my submissions. Thank you very much, my lady.
I think not. Mr. Coppell, was there anything you wanted to say about a reference, or indeed about the Tooling case, which
Yes.
I think we didn't look at before?
Yes. Well, Tooling, can I just deal with that briefly? Tooling is a classic indirect discrimination case because it imposed a disadvantage on women related to whether or not they had access to the workforce. So the benefit, there was a higher benefit paid if you had a dependent spouse. A man was inherently more likely to have a dependent spouse than a woman because the woman had childcare responsibilities, reasons for not being in the labour market in the same way as a man, and there's a reference to that at page 677 of the bundle in the Advocate General's opinion as to why this is understandably a complaint of indirect discrimination. It's a standard case. So far as a reference is concerned, of course I agree with Lord Panic that I would rather have a reference than a defeat. But I don't agree with him with respect that this case is about the application of well-trodden CJ EU principles. There are, in our submission, at least two new issues which are raised. The first is the first of the arguments on the other side is that paragraph 21 of Richards contains the implicit limitation that conditions can only relate to the medical or psychological condition of being a woman. And the second new argument, we would say, is the argument that a condition set pursuant to the instruction given by the Court of Justice in Richards could itself be directly discriminatory, even though it only applies necessarily to transsexuals. Now, we say those two new arguments can be disposed of by this court in our favour, but they are new arguments. Thank you.
Thank you very much indeed. We're extremely grateful to you all for your arguments, and we will now consider what to make of them and let you know in due course. Court is now adjourned.